Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I'm Mary, and I'm here with my co-host, Aaron. Today, we're answering one of the most common questions people have about mandamus lawsuits. How long does the process actually take?
This is a practical question that matters to everyone considering this option. You've already been waiting a long time for your immigration case. If you're going to file a lawsuit, you want to know what kind of timeline to expect.
So let's get into it. Is there a simple answer?
There's no single answer because every case is different. But we can walk through the typical stages, the factors that affect timing, and what the overall patterns look like based on how these cases generally resolve.
Let's start with the procedural framework. What are the key time periods built into the process?
Once a mandamus complaint is filed and properly served on all defendants, the government has 60 days to respond. That's longer than the typical 21-day deadline for private defendants, because federal defendants receive additional time under the rules.
So that's the first benchmark, 60 days.
Right, and in practice, the government often requests an extension of 30 days or more to prepare its response. Courts routinely grant these extensions, so realistically, the initial response period can stretch to 90 days or beyond.
What happens during that time?
The case gets assigned to an assistant U.S. attorney who contacts USCIS or the relevant agency to gather information about the delayed application. This is often when movement happens. The agency pulls the file, reviews it, and in many cases decides to simply adjudicate the application rather than defend the delay in court.
You mentioned that many cases resolve during that initial period. How common is that?
It's quite common. Many applicants report that their immigration cases are adjudicated within weeks of the lawsuit being served, sometimes even before the 60-day response deadline arrives. The lawsuit creates urgency that didn't exist before.
Why does filing work so quickly in those cases?
Because defending a lawsuit takes time and resources. The assistant U.S. attorney handling the case has to coordinate with the agency, review the file, and prepare a legal response. In many situations, it's far easier for the agency to simply decide the pending application than to engage in litigation over why it hasn't been decided.
So in the best-case scenario, an applicant could see resolution within a month or two of filing.
That's possible, yes. Some applicants receive decisions within days or weeks of the lawsuit being served. But it's important to set realistic expectations. Not every case resolves that quickly.
What about cases that don't resolve quickly? What extends the timeline?
Several factors can extend the process. If the government decides to contest the case rather than simply adjudicating the application, the litigation moves into the next phase. The government might file a motion to dismiss, arguing that the delay is reasonable or that the court lacks jurisdiction.
What happens then?
The plaintiff has to respond to the motion, the government may file a reply, and then the court takes time to decide the motion. Depending on the court's docket, this process can take several months. If the motion is denied, the case proceeds further. If it's granted, the case may end, though the plaintiff could appeal.
So contested cases take significantly longer.
They can. A case that proceeds through contested motion practice might take 6 months to a year or more to reach resolution. And if the case goes all the way to a court ruling on the merits, that adds additional time.
What factors influence whether a case resolves quickly or takes longer?
Several things. First, the strength of the case matters. If the delay is clearly unreasonable, the application has been pending for years with no action and no legitimate explanation, the government is more likely to resolve the case quickly rather than try to defend the indefensible.
What else?
The specific court matters. Federal district courts have different caseloads and different speeds. Some courts move quickly, others have significant backlogs. The jurisdiction where you file can affect how long it takes to get rulings on motions or schedule hearings.
Does the type of immigration application matter?
It can. Some types of applications have stronger legal arguments for mandamus. Naturalization cases, with the 120-day rule under Section 1447B, for example, have a clear statutory timeline that strengthens the plaintiff's position. The nature of the delay also matters. If there's a pending background check versus simple administrative backlog, the government's defense may differ.
You've mentioned that cases can settle. How does that affect the timeline?
Settlement is a common resolution in mandamus cases, and it can happen at various points. Sometimes settlement discussions begin shortly after the lawsuit is served. Other times, they happen after the government files its response, or even after motion practice has begun.
What does settlement look like?
Typically, the government agrees to adjudicate the application within a specified time frame, say 60 or 90 days, in exchange for the plaintiff dismissing the lawsuit. This gives both sides certainty. The applicant knows when they'll get a decision, and the government avoids further litigation.
So settlement can shorten the process.
It can. If the parties reach a settlement agreement, the case can conclude relatively quickly without waiting for court rulings. The key is that the applicant gets what they wanted, agency action on their application, and the lawsuit has served its purpose.
Based on how these cases generally unfold, what should applicants realistically expect?
The patterns vary, but here's a general framework. A significant number of cases resolve within the first few months after filing, often because the agency adjudicates the application once the lawsuit creates accountability. Many practitioners report that cases frequently resolve within 30 to 90 days of service.
And for cases that don't resolve quickly?
Cases involving contested motions or more complex circumstances may take 6 months to a year. Cases that proceed to a full court ruling can take longer. But it's worth noting that even in contested cases, the agency sometimes adjudicates the application during the litigation, making the case moot.
So resolution can come from the agency acting, not just from the court ruling.
Exactly. The goal is to get a decision on the immigration application, whether that happens because the lawsuit prompted the agency to act or because the court ordered it. The outcome is the same. The applicant finally gets an answer.
How does the mandamus timeline compare to just continuing to wait?
This is an important perspective. Many applicants considering mandamus have already been waiting years for their immigration cases. If you've been waiting 3 years with no movement, and a lawsuit might resolve the matter in a few months, the comparison is favorable.
Even if the lawsuit takes 6 months or a year?
Even then, for many applicants. Without the lawsuit, there's no indication that the agency will ever act. The wait could continue indefinitely. With the lawsuit, there's a defined process with deadlines, accountability, and a mechanism for resolution. You're trading indefinite uncertainty for a structured path forward.
So the relevant question isn't just how long the lawsuit takes, but how long you'd be waiting without it.
Exactly. For someone whose case has been pending for years with no end in sight, even a lawsuit that takes several months represents significant progress compared to the alternative of continuing to wait with no recourse.
What should applicants understand about timeline expectations going into this process?
A few things. First, there are no guarantees about how quickly any individual case will resolve. The patterns we've discussed are general observations, not predictions for specific cases.
What else?
Second, the timeline is not entirely within your control. The court schedule, the government's litigation decisions, and the agency's internal processes all affect timing. Your attorney can advocate for prompt resolution, but external factors play a role.
Any other considerations?
Third, be prepared for the possibility that the process takes longer than you hope. While many cases resolve quickly, some don't. Going into litigation with realistic expectations helps manage frustration if the case doesn't resolve in the first few weeks.
If someone is considering filing a mandamus lawsuit, what should they ask their attorney about timing?
Several questions are worth asking. What is your experience with how long these cases typically take in this jurisdiction? What factors in my specific case might affect the timeline? What is your strategy for encouraging prompt resolution?
What about communication during the process?
Ask how the attorney will keep you informed about developments. Will you receive updates when documents are filed? When the government responds? When there's movement on the underlying immigration case? Clear communication helps you understand where things stand throughout the process.
And expectations about resolution?
Ask the attorney to be honest about what they've seen in similar cases. A good attorney won't promise a specific timeline, but can give you a realistic range based on their experience. Be cautious of anyone who guarantees quick results. Litigation inherently involves uncertainty.
Let's summarize the key points from this episode.
First, after a mandamus lawsuit is served, the government has 60 days to respond, often extended to 90 days or more. Many cases resolve during this initial period because the lawsuit prompts the agency to adjudicate the pending application rather than engage in litigation. Some applicants see results within weeks of filing.
Second, cases that involve contested motions or proceed to court rulings take longer, potentially 6 months to a year or more. Factors affecting timeline include the strength of the case, the court's docket, the type of immigration application, and the government's litigation strategy. Settlement can occur at various stages and often shortens the process.
Third, while there are no guarantees about timing, the mandamus process provides a structured path forward with accountability and deadlines. For applicants who have been waiting years with no movement, even a lawsuit that takes several months represents progress compared to indefinite waiting. Realistic expectations and clear communication with your attorney help manage the process.
Thank you for listening to the Mandamus Lawyers Podcast. Mandamus Lawyers is a law firm focused exclusively on federal court litigation for immigration delays. Visit mandamuslawyers.com.